It's my pleasure to introduce Scott Shapiro. Scott is the Charles Southmaid Professor of Law and Professor of Philosophy at Yale University. Scott's perhaps the leading thinker today on the nature of law, and happily for this part of the philosophical community, he also does a tremendous amount to connect the philosophy of law with work done in recent years on collective intentionality and social ontology. He's written about this in a number of places, but most prominently in his 2011 book titled Legality, and I can attest to how kind of rewarding and interesting a read it is. My colleague Aaron Kelly and I taught it in a seminar on legal institutions about a year ago, and it provoked a bunch of very spirited debates. Scott is also the co-editor of the Oxford Handbook of Jurisprudence and Philosophy of Law, and that's a fantastic resource I highly recommend. I've used it a ton. He also just came out with a new, very interesting book on the history of international law since the 17th century. So it is my honor to welcome Scott Shapiro for this afternoon's keynote.
Hi, thank you so much, Brian. It's a real pleasure and honor to be speaking here today, and I really appreciate Brian's invitation to speak. I really admire Brian's zeal in getting philosophers to think seriously and rigorously about the social world, about spreading the importance of doing so, and about the amazing group of people that he's assembled all in one place, and also to hi to all the Facebook people out there. After this, after the talk, please delete your account. Well, people like Facebook here. Okay, what I'd like to do today is talk about how my own research in legal philosophy has sought to leverage the insight of philosophers of social action and how we might gain a greater appreciation about the nature of law by taking sociality more seriously. It's interesting to me because it's almost 20 years to the day that I started thinking about how the social ontology and collective intentionality relates to the law. I was invited in September, I think, of 1998 to a conference in Amsterdam on intentions, and I remember Michael Bratman's Faces of Intention had just come out, and one of the assignments was to read the essay Shared Intention and Shared Cooperative Activity, and I remember being on the plane reading it and thinking, wow, this is what the philosophy of law needs. And also I was like amazed that there was like a new idea in philosophy. So I want to just try to spell out a bit how my thinking has gone in terms of the relationship between law and social action. Now, in some sense, legal philosophers are very fond of saying that law is a social practice. They say all the time, law is a social practice. Now, what do they mean by that? I don't know. I have absolutely no idea. And I don't think they do either, because it's such a banal thing to say. Well, obviously it's not an individual practice. So like what would it mean to say it was a social practice? So one of the things I'd like to do today is to try to identify the various different ways in which we might try to cash out the idea that law is a social practice. And I'd like to do it by developing, in part developing, part recounting my own way of thinking about the nature of law, what one might call a theory about the essence of law, that is, those properties, the possession of which by some entity makes it a legal entity. And what I'd like to do is kind of develop it kind of step by step, and just so you can see which properties kind of go into making law, but also which properties are properly understood as social in nature. Now, in trying to develop a theory about the nature of law, it's kind of very tempting, I think, to begin with the idea of an organization and then asking what makes a legal organization a legal organization. And I want to resist that temptation in part because, at least in jurisprudence, there hasn't been any work on what an organization is. And I'd be curious to hear afterwards whether in the philosophy of social action, whether there's been a lot of work done on what an organization is. I mean, there's certainly been a lot of work on what an institution is, but organizations are a particularly important subset of institutions. And so what I'd like to do is, by trying to build up to law, I'd like to also try to build up to what an organization is. Now, where would I like to start? I'd like to start with the idea of an activity. So an activity is a pretty basic concept. It's pretty well understood, pretty well developed by philosophers of action. And what I'd like to do is I'd like to ask what makes an activity an instance of legal activity. Okay? Now, for ease of exposition, and by the way, does everyone have the handouts? Because I'm going to follow the handout. I like handouts way better than PowerPoints because, at least when I'm in the audience, because I can tell when it's almost going to be over. And so I'm at the beginning right now. Just so for your own pacing. Okay, so I'd like to begin by, just for ease of exposition, calling the exercise of legal authority legal activity. Okay? So when legislators legislate, regulators regulate, or judges adjudicate, they're engaged in legal activity. So the main question that I'd like to talk to you today is, what makes the activity of legislators, regulators, and judges legal activity and not some other kind of activity? Now, the basic idea of what I call the planning theory of law is the idea that legal activity is the activity of social planning. When Congress enacts legislation, they're adopting plans for us, or to put it somewhat more dramatically, they're planning our lives. They're deciding which actions we may or may not do, and which people may or may not engage in that planning activity. Courts on this view figure out what those plans require, permit, and authorize us to do. And what I'll say is that legislators adopt plans for the community, and courts apply those plans to whom that they apply. Now, the idea is that planning is not just something that we do for ourselves. Planning is something that we can do for others. So I plan my children's lives. The dean of my law school partially plans the faculty's life. The city of New Haven plans the lives of the residents of New Haven. And of course, authorities don't completely plan our lives. We plan our lives as well. It's just that their plans override ours when they conflict. Now, you might wonder, what is added by saying that legal activity is planning activity? Why not just say that legal activity is the making and applying of rules? What is added by talking about planning? So here, what I'd like to do is borrow from Michael Bratman's work, who has, over the course of his career, argued that planning is a very specific kind of way of guiding conduct. It's actually very unique, and it has specific properties and associated norms. So one of the most important things that Bratman emphasized was the fact that planning is typically partial. We don't plan all of our activity all at once, but what we do is we settle on certain behavior at a kind of a very broad, crude level of description, at the beginning, and we fill it in over time as more information becomes available. So for example, if I see you in the hallway and we say, hey, you want to have lunch, your reaction is not going to be, okay, but like when, where, how are we getting there, who's tipping, what are you ordering? I mean, if somebody did that, you'd be like, oh, I'm sorry, I'm busy. The idea is like you'd say something like, oh, okay, yeah, totally, I'm free Monday, and you're like, okay, I'll email you. And then on Monday morning, you'd email and say, hey, when you want to get together? And you say, oh, let's meet in front of the law school, or blah, blah, blah. You get the point. The point is that planning is typically partial and is filled in over time, and this partiality of planning is a rational way of proceeding because it gives us a certain degree of flexibility. It fixes enough of our behavior so that we can coordinate not only our other activities, but the activities of, with other people. But it also gives us a measure of flexibility so that when we learn more about the world, we can fill in those that information compatible with the framework of prior decision making. Okay, now the claim that I'd like to make is that legislation is also incremental in much the same way. Rarely are whole codes enacted all at once. Legislatures often set ends to be achieved and then either fill in the legislation over time or they delegate that task to other bodies such as administrative agencies and courts. So if you, on the handout, so if you see like, in 1890, Congress, the US Congress enacted the Sherman Act, which prohibits certain forms of restraint of trade, basically anti-monopolistic practices, but they never bothered to say what that entailed. And in the process of trying to figure out what restraints of trade were, Congress acted to enact the Clayton Act and the Robinson-Patman Act, along with other acts, which filled in what restraints of trade or unfair methods of competition entailed. Meanwhile, courts also engaged in the same activity. There were lots of court decisions that came up interpreting the Sherman Act and then later the Clayton and Robinson-Patman Act, filling in over time what restraints of trade are. And it wasn't just courts and later Congresses, but in fact, that's what the administrative state does. So after the Federal Trade Commission Act was passed in, luckily no one here is going to correct me, so I'm going to say 1923, the Federal Trade Commission engaged in many forms of regulation. I mean, they're unbelievably specific, unbelievably tedious. I mean, just if you ever want to see what our government does, go to look to what the Federal Trade Commission does. They narrow things down to the incredible specificity. My favorite is Dijon mustard. Its pH has to be like within it's something like the 7.3 to 7.41 or something like that. I mean, these are unbelievably specific guidelines, and the thought that I want to get across is the idea that like this all makes sense from a social planning perspective. If you want institutions to act in a rational fashion in guiding conduct, you should expect them to engage in this incremental process of filling in over time, and also for it to be distributed by across multiple institutions, given their comparative advantage. Okay, what do I mean by social planning? The sociality of the planning is manifested in at least three ways. One is that they're plans for the community. That is, those are the subjects. Number two, they're social in the sense that they're publicly accessible, in the sense that they are in principle knowable. And then finally, they are general policies. That is, it's not like the law says, you do this, you do this, you do this, you do this, but rather, on April 15th, income producers ought to file their tax forms. Okay, so that's the first claim I want to make, that legal activity is the activity of social planning. The second claim I'd like to make is that legal activity is shared activity, which is to say that it's a collective activity. That is, it's not just the case that legislators and judges and regulators engage in the making and application of plans, but they're doing it together. That is, they're each playing their role in the collective activity of social planning. Now, this is I hope it seems intuitive to people that legal officials are all engaged in a collective activity of regulating the community. But this is, in fact, not a position that any of the legal philosophers that I know of took when I started writing. So take H.L.A. Hart. So Hart, as many of you know, thought that what legal officials are doing when they're in a legal system is they are following the same set of social rules. And those are the special kinds of rules he called secondary rules, the rule of recognition, the rule of adjudication, and the rule of change. But there's no sense in Hart's theory that by following these social rules that they're actually engaged in a collective activity together. It's like when you take off your hat in church, everyone is following a social rule, but they're not all taking off their hats together as if they were in a cabaret line, right? They're just following a sense of what they're supposed to do. Hart has that same idea, I think, that it's just like the legislator is doing what the legislature is supposed to do and the judge is doing what they're supposed to do, but there's no sense of connection between them. Now, what connects them? Well, the claim I'd like to make, and I can't substantiate it here right now, though happy to talk about it later, is that what connects them is the fact that legal officials are all following the same plan, a shared plan. That is the constitutional law of a community, of a legal system, is a shared plan amongst officials. It is a shared plan for social planning. So this plan, what it does is it allocates roles to different officials, and it tells them their parts that they are to play in the collective activity of social planning. And now this kind of flips the standard way of thinking about law, because the standard way of thinking about law, like one of the questions that legal philosophers care about is the so-called question of the unity of law. What makes it the case that all the laws of a particular legal system are laws of that legal system? And so Hart has the most influential response, which is to say, well, they're all validated by the same social rule, the rule of recognition. So it's that the normative unity of the legal system depends on the normative unity of the rule of recognition. The only problem is that Hart never justified why the rule of recognition was one rule as opposed to lots of rules. He just kind of helped himself to the unity of the rule of recognition. The way I'd like to approach it is rather to see the unity of the law as being given by the unity of the group that's making and applying it. It's the fact that the laws are all the laws of the same group, which makes it the case that they're all part of the same legal system. So to put it in one line, is that the normative unity of the law is dependent upon and is grounded in the social unity of officials. Okay. Okay, number 3, legal activity is official activity. What do I mean by that? What I mean is that legal actors, those who engage in legal activity, occupy offices. And what's an office? An office is a relatively stable position of authority designed to deal with recurring problems where turnover in inhabitants is not only possible but normal. So what I mean by that is, the dean, that's an office. The pope, the papacy, that's an office. There's an idea that there's supposed to be turnover. Parenthood is not an office, because although it is, of course, possible for parenthood to turn over, it's not the kind of the expected course of events. People don't tend to lose their parental rights except under extraordinary circumstances, whereas you expect that there's turnover among officials all the time. So parents do engage in a shared activity of social planning, so to speak, for their family, but it's not official activity because parents don't occupy offices. Okay. Number 4, legal activity is institutional activity. Now, what do I mean by institutional activity? What I mean is, and it's institutional is one of those horrible words that can mean anything. So I'm going to make it mean this for the purposes of history, which is that normative relations may obtain between people independent of the particular intentions of the relata. Meaning that it doesn't matter what you're thinking. It doesn't matter what you're intending. You just have to follow the procedures. So, for example, I mean, it's a classic thing in legislatures. I mean, if you've ever seen omnibus bills, or I mean, take the corporate tax cut that was enacted. I don't know what, 6 months ago. Nobody had read it. I mean, some people had read parts of it, but nobody had read the whole thing. And all they needed to do was to vote yay on it, have a majority to do it, and that counted as having been enacting the legislation. So the idea is that it doesn't matter what you're thinking. What matters is, are you following the rules? It's kind of like, home run. Like, you don't have to intend to hit a home run. You just have to hit it, and the ball will go over the fence with the right setup. Okay, so we have so far the following 4 properties of legal activity. Legal activity is the shared activity of social planning, which is official and institutional. Now, I'd like to claim, at least to a first approximation, that what an organization is, and that's towards the end of the first page, an organization is a group engaged in a shared official and institutional activity. When you have a group that is engaged in a shared official institutional activity, you have an organization, and when that activity is an activity of social planning, you have a planning organization. Okay? So that's where we are right now. But we not all planning organizations are legal systems, right? We know that. That's obvious. I mean, we have, party planning, the party planning committee, right, is not the law. thank God. Okay, so what do we have to add to activity to make it legal activity? Well, I'd like to suggest we have to add at least the idea of compulsoriness. That is, you can't quit the law. That is, you can quit your job, but you can't quit the law. It is never, I should say, it's virtually never a legal defense to say, I don't accept your rules. Try it. It won't work, unless you're the president. I beat you, thank you. Yeah, of course. I mean, there's nothing else to think about these days. Okay, so in that sense, legal activity is like parental activity. Like until the age of maturity, you can't quit your parents, or unless you engage in some form of emancipation. So parental activity is compulsory activity, but it isn't organizational. Legal activity is compulsory and organizational. Okay? Now, is it the case that a compulsory planning organization is a legal organization? No, because I have another side of the handout to go. So you know that I am not finished. Okay. I want to claim that what makes legal activity is, at least in part, that it has a particular constitutive aim. And that constitutive aim is moral in nature, and it essentially requires that those who engage in legal activity solve those moral problems that could not be solved or solved as well by less sophisticated forms of social planning. There are lots of kinds of social planning that are less sophisticated than legal planning. There's individual bargaining, there's consensus, there is improvisation, there's spontaneous ordering. There's non-institutional modes of guiding conduct. To add all the features that law has makes it highly sophisticated, because not only do you have these plans for planning, but the plans that are created don't require lots of knowledge on the parts of the members of the community for those plans to be created. That's the part of the point I was trying to get at by talking about the corporate tax cut. It would be really difficult for Congress to legislate if it had to know what it was legislating. Might be better, but it would be really hard for them to do so. And so it's actually quite sophisticated technique to say, as long as you follow these rules, these plans, these procedures, we will count your guidance as being guidance for the community. In that way, law is much more sophisticated than individual orders. Individual orders, you have to intend to give the order, whereas in the case of law, you don't actually have to intend to make law or even know what law you're making. So I call this the moral aim thesis, which is that the fundamental aim of legal activity is to remedy the moral deficiencies of the circumstances of legality. Circumstances of legality is supposed to mirror Hume's circumstances of justice. The idea being like, we live in this really, really complex, complicated world. And we need some way of solving the problems that arise because there's so many of them. Those are the circumstances of legality, and that the constitutive aim of the law is to solve those moral problems. Now, the law almost always fails at its constitutive aim. It succeeds partially, but it doesn't actually have to succeed in order to have the aim that it has. So, for example, like you could think of the constitutive aim of assertion as being to tell the truth, even though the assertion is false, or in fact even a lie. It would still be an assertion because its constitutive aim is to convey the truth, despite the fact that it failed in what it's supposed to do. Now, why say that the law has a constitutive aim that's moral? Well, here's a couple of considerations on the next page. Number one, this is why we don't criticize hunter-gatherers for not having legal systems. You don't criticize them for not having legal systems because they don't need it. Whereas if we had a modern system that didn't have a legal system, for example, like the closest, in part Syria, part Venezuela, you have really no institutions that will solve problems that need to be solved by sophisticated planning institutions, whereas hunter-gatherers, they can just sit around and decide things by tradition and consensus. Number two, we don't criticize certain institutions for not solving moral problems, like baseball. It's not, baseball is criticizable because it's boring. It's not criticizable because it hasn't solved global warming. Whereas the legal system, our legal system, can and ought to be criticized for not doing what needs to be done in order to solve important moral problems. Another reason I think that it's important to think of legal systems as having moral aims is I think it's one of the ways in which we distinguish legal systems from organized crime. Organized crime typically comes into being when there are weak states, when there are need for norm enforcement, but the state is too weak to provide it. The difference between organized crime and the law is that organized crime is not there to solve moral problems. In fact, it's there to create moral problems. It would make no sense to talk about the mafia being unjust or the mafia don abusing his authority. That's what they do. Whereas, and let me also get to the flip side, when the mafia or the Yakuza do something good in the sense that they stabilize violence within a community, let's say, we think, well, that was lucky. Not exactly what I was expecting, but, that's serendipitous. That is adventitious. When the law does what's right, does what justice requires, we don't say, well, that's lucky. We say, good, that's what they're there for. Consequently, and the flip side is when they make life worse from a moral point of view, they are criticizable not just from a moral point of view, but from an internal legal point of view. They're not doing what legal systems are supposed to do. Okay, now that raises the question, what makes it the case that the law has the constitutive aim that it does? That is, I say that the difference between mafia and the law is that the mafia doesn't have a moral aim, whereas the law does. But I haven't told you what makes it the case, what grounds the fact that the law has the moral aim that it does. Now, one thing I'm going to reject is the idea that, obviously, that legal officials do the right thing, or even try to do the right thing, because we know they don't. I mean, not always, but lots of times, legal officials don't do the right thing, and yet they're criticizable for not doing the right thing. They're not doing what they're supposed to do. So what makes it the case that justice is what they're supposed to do? The claim I'd like to make is that it has to do with the avowals of the elites of the system. That is, they have to act as though what they're trying to do is solve moral problems. Now, how do they do that? Well, they do it explicitly by giving speeches, by saying, I don't know what they say. America should be the shining city on the hill, or make America great again, or whatever. They're always acting like they're there to make the community better off, morally speaking. They have ceremonial steels that they erect, which proclaim the importance of their actions. The preambles to constitutions always talk about the importance of justice. Prologues to legal codes, judicial dicta, and also just all the rituals associated with the law. I mean, they dress in these robes, and they meet in these things that look like temples, and they speak in Latin, and they wear wigs. And most importantly, they speak in moral discourse. They talk about rights that we have. They talk about the authority they possess. They talk about the duties that they require and the obligations that we must satisfy. Okay. So, thus far, legal activity is the shared, official, institutional, compulsory activity of social planning with a moral aim. Alternatively, legal systems are compulsory planning organizations with a moral aim. Are we done yet? Of course not. Got another third to go. And I'm going to focus here on something that when I was working on this, I spent the most time on. And I found it the most vexing part of trying to develop this, which was condo boards, which are not just really vexing in jurisprudence, but are just vexing in real life. Take any condo board. They make rules for the condominium inhabitants. They decide cases, like if you have, there are supposed rule violations, you go before the board and you plead your case. They have offices. There's a division of labor. There's the treasurer, the secretary, the chairman of the board. There are procedures. There are elections. They make rules. But the condo boards are not the law. And you could say, I think you could say they're also compulsory. That is, if you want to live in the condo, you got to listen to their rules. And it's an organization. So why is the condo board not the law? What makes the law special? Now, it took me a long, long time to develop this last part, and please don't anybody show me I'm wrong, because I know that's like the wrong thing to ask, but I'll be really hurt. Let me try other people who've offered suggestions, which I'm perfectly happy to say that they're wrong, because it's really about me, not about them. And that, let me take Joseph Raz's two suggestions. Joseph Raz has said that what makes the law is that it claims supreme authority within a community. Now, that would explain why the Condo Board was not the law, because the Condo Board does not claim supreme authority. Florida law, let's say, if the condo is in Florida, which many are, in the case of Florida law trumps the condo rules. Now, that might seem like a good solution, but it isn't. That's because if supremacy was a necessary condition for legality, then Florida wouldn't have a legal system. Because under the Supremacy Clause of the United States Constitution, state law is subordinate to federal law. So if the Condo Board is not a law because it's subordinate to Florida law, then Florida wouldn't have a legal system either because it's subordinate to federal law. Okay, what about comprehensiveness? Another suggestion is that what makes law is that it claims the authority to regulate any type of activity. Now, the condo doesn't claim to regulate any kind of activity, but the law does, and certainly Florida law does. Now, that I don't think that works either. I think partly because I think it's just a contingent matter that condo boards don't. I mean, you could fully imagine them doing that, and some try. But also I think it's anachronistic. It's anachronistic because it's true that modern legal systems are comprehensive, but that's like a relatively recent phenomenon with the rise of the territorial state. If you think about, medieval 13th century England, you had manorial law, which regulated feudalism, ecclesiastical law, which regulated church property, issues of sacrament, and relatedly family matters and inheritance. You had mercantile law, which regulated transnational business transactions. I mean, you had lots of subject-specific legal systems stacked right next to each other. And so I think that it's not a necessary condition for the existence of a legal system for it to have comprehensive authority, because I don't think they typically have had comprehensive authority in the past. Here's the proposal, okay? The proposal is that, now it's under the handout called proposal, okay? The proposal is as follows. Although state law must comply with federal law automatically presumes that state law complies with federal law. By contrast, states afford no comparable presumptions to private entities such as the Condo Board. What I mean by this is follows. We have relations of superiority between the Condo Board, Florida, and federal law, right? But there is an asymmetry here between the superiority of Florida law to the Condo Board and federal law to Florida law, and it's as follows. Even though Florida is required to conform its rules to federal law presumes that Florida has done the right job. It presumes constitutionality. There's a presumption that Florida has acted in the legally right way vis-a-vis federal law. And because there's a presumption of validity between federal law and state law, federal law permits the states to enforce their laws as they see fit. Not so with the Condo Board. Even though the Condo Board is supposed to have its rules comply with Florida law, and also federal law, but certainly Florida law does not give the same presumption of validity to the Condo Board. So the Condo Board, if it wants to enforce some of its rules, the state does not necessarily give them the right to do it. So the example that I would give is take skinny dipping. If swimming without clothes on is against the law in Florida, then, and assume that that's constitutional, constitutional from at the federal level, okay? If the Florida State Police want to enforce that rule, they don't have to go to the FBI first. They can just take the person out of the pool and arrest them. But let's say the Condo Board had a similar skinny dipping rule that it wanted to enforce, and assume that it was within its power, that it didn't violate Florida law to prohibit skinny dipping. It still does not enjoy the same presumption of validity such that it could go and yank the naked person out of the pool. It has to call the police first. Now, this presumption of validity is terribly, terribly important, and I think non-lawyers may not appreciate how important it is. I assume many of you have heard about the legal controversies about the Voting Rights Act, right? One of the reasons why many people, especially Republicans, hate the Voting Rights Act is because it's one of the only times that federal law denies states the presumption of validity. What the Section 5 of the Voting Rights Act says is that if you change the voting rules and you're in a covered jurisdiction, you're in a jurisdiction which has historically bad voting practices, you have to go to the Department of Justice for what's called preclearance. And this drives people bananas, okay? Because it denies states the presumption of validity that they enjoy everywhere else and which private entities do not enjoy. And so the claim I want to make is that what makes the Condo Board, even though it is a compulsory planning organization, not a legal system, is because it does not enjoy the benefit of the doubt from other superior planning organizations. Okay. Let me just make one claim and then I'll be finished. The presumption of validity, which legal systems enjoy from their superiors if they have any, that presumption is rebuttable. And how do you rebut it? You go to court. That's how you rebut the presumption of validity. You go to court, you sue Florida in federal court, and you say Florida law is unconstitutional. At that point, the presumption is rebutted, and then the superior planning organization, which is the federal government, will adjudicate the claim. So, conclusion. Legal activity is the shared, official, institutional, compulsory, self-certifying activity of social planning with a moral aim. Alternatively, legal systems are compulsory, self-certifying planning organizations with a moral aim. Thank you.
Wow, okay, let me take a minute and write down some questioners. Please keep your hands high. Let's start with the person in the honors. Please keep your hands up for the duration of the first question.
Ooh, first question. I'm Katrina. Thank you. I'm over here. Hi.
Hi, sorry.
Yeah, thank you again. You talked a little bit about hunter-gatherer societies, and I'm not asking you to do a lot of historicizing now. I think that's probably not going to answer my question, but I'm just wondering at what point you think a society has like reached a critical mass or has like amassed a certain amount of like social resources such that it's necessary to build a legal system.
Yeah, so what I do in my book Legality is I like build a legal system exactly in that kind of, I call it Cook's Island. These bunch of people, they come to an island and they start engaging in hunting and gathering, and they start developing a more complex social forms, and I kind of walk through like what is the case requiring greater sophistication in social planning. Basically, the thought here is that as the division of labor in society gets more complex, it's both the case that the need for plans increase, that is, the demand for plans increase, but also the cost of supply also increases because it becomes that much harder for people to make plans when they're all doing different things. Mm-hmm. And so that I tell a fictitious kind of just so story just as a way of seeing what kinds of aspects of the circumstances of legality would be appropriate for the introduction of a legal system. Yeah.
Thank you.
Yeah. So I would just I tend to be extremely cynical about these things in the sense that I think that my view about law is that it's power with a very thin veneer of bullshit. In the sense that I think that elites, they make claims which they oftentimes don't believe and know that that's what you're supposed to do. It's like acting. Like, what makes you an actor? What makes you an actor is you pretend to be somebody else within a certain context. You don't have to believe it. In fact, you're not supposed, I guess you can kind of believe it in the method sort of way. But like also assertion is like that. You have to kind of avow the truth, even if you're lying. And so it's really important to the view that those avowals need not be sincere. And I think that like, it's not just the avowals, it's like everything about the law is dressed up in kind of this ridiculous pomp and circumstances. Law schools look ridiculous. My law school, we have stained glass all over the place. The ritualized nature of what we teach our students to do. Oh yes. It's all ridiculous. But that's like kind of part of the mystique that this institution is here to do something that no one else can do, which is to solve the problems of justice, which desperately need to be solved.
Thank you. So I have a question about the requirement of that the legal activity is compulsory.
Yeah.
And you said the Condo Board, the rules of the Condo Board would be compulsory. I have to move out of the condo if I reject the rules, right?
Right. Or you may not even be able to. I mean,
Right.
you may not even be able to move out.
Okay. So I can leave. If I leave my job, if I quit my job, then I have to leave my office. I can't stay there.
That's true.
So is that also compulsory? If it's a requirement that I have to leave? Because of course I can leave a jurisdiction, and people do because the law is bad in one jurisdiction, and so they flee somewhere else. So could you say a little more about the notion of compulsiveness here? Because I'm not sure
So what's complicated here, what's complicating things here, is that lots of times authority and property law get mixed up together. Okay, so like when I tell you get out of my house, I'm not exercising authority over you. I'm telling you that this is my property and it's up to me who's within the borders. And I think that that's what's happening with the job thing. It would make kind of no sense for if you're the employee, you say I quit, and your boss says tough. I'm still going to tell you what to do. I mean, that would like. Whereas it that's completely the situation with kids, because kids always say, "I'm quitting this family," right? And it's kind of funny because you can't. And so that's what I would say about the. I mean, there's just a funny kind of thing that happens is that lots of times, property rights, people can simulate authority through the exercise of property rights, but it's actually not a form of authority in the sense of authority over the person. You flick the thing up.
It is now.
Great.
I'm Teresa. So I have a question about the constitutive rule or constitutive aims.
Aims, yeah.
Aims, okay. So I didn't see entirely well how the analogy with assertion was supposed to work in the way you presented it. So I was wondering whether you could say a bit more, and I'll explain what I didn't see. So in the case of the law, we presumably know that there have been societies and communities that have had apparently legal systems and they were not moral at all, right? And so what you're saying is that, well, they were failing in their constitutive aim. They were failing to attain their constitutive aims. But this could have been communities and societies that were a long, long time, like centuries under, I don't know how moral the Romans were, but we could imagine, if not the Romans, some other society that lasted for centuries that was not particularly moral in their aims, but had legal systems, very complex legal systems. It sounds very odd to say that we could conceive of something similar. We know that people lie, but it would be weird to say that there are these communities that engage in assertion for this really huge stretch of time, or they just lie all the time. Everybody lies all the time, and that's how. But they're still asserting. It would feel like their assertion doesn't. If what they were doing was not assertion, whereas in the Rome, let's assume, or whatever, some other society, it will seem that they still have legal systems even though they are immoral. Or they don't try to attain moral aims. So that felt like that there was a difference in how you were.
Yeah, sure. So, thanks for the question. So I mean, it's funny that you should say that about Rome. I mean, there was a time in this country, like the founding generation, where to be Rome was like to be the highest form of government, and Roman law was like the ideal form of law. Now, it's actually it's a whole the history of the Western reception of Roman law is fascinating, especially the way that the Nazis demonized Roman law for its materialism. But I think a claim could be made, and I think it would be a valid claim, that, you know, Rome did some good things, it did some bad things too. I mean, the Nazis actually did a lot of good things. They also did a lot of terrible things too. But they were actually, in many ways, highly egalitarian and democratic for Germans. And my colleague, Jim Whitman, has written a lot about this, the way in which what the Nazis tried to do was try to extend the privileges of aristocracy to ordinary people as a way of lifting up the dignity of ordinary Germans. And that's why they created dignity courts. They created a lot of things that were morally good. Now, of course, they did unbelievably atrocious things. So I think I guess the point that I want to make is that when we assess whether a legal system has satisfied its moral aim, it's always a matter of degree, right? Some of them do much better jobs than others, and they do much better jobs at certain times than others. And I guess that's what I would say. It's not like for the history of the world until Sweden, post-war Sweden, every legal system failed miserably. It failed at some parts and succeeded at other parts, and hopefully it's, you know, getting better.
Since you asked us to question your principle of validity, here I am. So let me let me try to figure out. Let me give you two examples which I think are examples of why you are mistaken.
Okay.
So the first one is, imagine we're in the U.S. federal system, happy and dandy. Florida is still presumption of validity in almost everything, and suddenly we change the Constitution. We create a constitutional court that what they do is every law that is passed in the nation goes through them to make sure it is constitutional, and then it is implemented. So now all legal systems don't have the presumption of validity with the way you seem to be defining it, which will mean that suddenly by creating this one constitutional court that functionally lets everything pass, you are destroying every system of law in the US. And a similar concern is the part about, the enforcement. Like you need somebody else to enforce your ruling, therefore it cannot be law. That was the example that you gave, right? You need the cops to come to the condo. The problem with
you don't need you don't need the cops to come to the condo. You need somebody to sign off.
Yes.
On it, which you may be able to do it yourself. It's just somebody has to sign off on you doing it. So you don't. So the idea is that, admittedly, I went through this really quickly, so I didn't give you the precise condition. But the idea is that you don't have to have somebody else enforce the rules for you. You just have to make sure that somebody passes judgment on whether your rules are valid. Now, it just so happens that in most cases, the ones who do that are also the ones who enforce, but that's not part of the condition. But there's no way you would know that because I didn't state it. Yeah.
I cannot read minds yet. I'm not sure then if it holds, but ecclesiastical law, as you mentioned, in medieval times, the only way they many times the punishment was passing you to the temporal arms. That's
Yeah.
what they called it.
Yeah, of course.
So you still think ecclesiastical law is a law, the enforcement is outside, but will you consider that the fact that they gave you up, because sometimes the punishment was chosen by the temporal things, like how much they will put you in prison, etc. So there seems to be a judgment from the non-ecclesiastical authorities, explicitly non-ecclesiastical, so they could punish, because the clerics couldn't. So there is that undermining, because that seems to be undermining this self-certification in a sense, even if both of us agree ecclesiastical law is a law.
Yeah, so let me get to the second one first. So the prohibition on God, now I'm forgetting exactly the term. It's when the ecclesiastical that handed them over was called not rendition. It was called, anyway. The point was the reason why the ecclesiastical courts handed over defendants for corporal punishment was just the idea that the court was not that the church was not allowed to shed blood, right? So that has nothing to do with the presumption of validity. That's just like an accepted prohibition of one system not to do something. It wasn't a requirement of the secular courts or the king. It's not like the king said, "You may not shed blood." They themselves. So the first one was you'll have to walk me through it. So here we have this idea of we're going to have an abstract judicial review of all rules before they become law. Okay, we'll talk about this afterwards. It's actually very interesting. Yeah. Oh, wait, oh, okay. I'm sorry.
Thanks very much. That was excellent. But, just a quick question on following the condominium problem. And there's various possibilities in 3 bullet points, but you didn't seem to say much about the monopoly on the legitimate use of force.
Yeah.
But later on you say that enforcement is not necessary, which seems right. I mean, it might not be necessary.
Yeah.
But the monopoly on the legitimate use of force, the potential to be able to lock people up legitimately or take things off them, it might seem that's a pretty classic way of saying what law is and other things aren't. It's almost a sufficient condition for a legal institution that it can lock you up legitimately, right? So it's just a question of what were you meaning to put that aside because it's in your 3 sort of.
I put that aside because I was worried about running out of time, but I'm happy to talk about it right now. So the Weberian principle is not about law; it's about the state. Right, so the Weber in Politics as a Vocation suggested that what makes the state is the fact that it claims a legitimate monopoly over the use of force within a given territory. And so, at the time, one possibility you might say is that the Condo Board doesn't have a monopoly over the legitimate use of force, whereas Florida does. And so that may be a distinction. It's just that I don't think that works for several reasons. The first reason is that, again, I think that that's a defining feature of the state. So Iceland, now we're back to Iceland. Iceland, nobody had a monopoly over the use of force. I mean, that's why it didn't have a state, but it had a legal system. That's the first reason. The second reason is that I don't even think the state has a monopoly over legitimate use of force. I mean, insofar as that individuals have the right of self-defense, and also insofar as you think that international law makes claims on domestic systems about who can use force. I don't even think domestic law claims a monopoly over the legitimate use of force. So I don't think that works, and it doesn't work for so many reasons that I skipped it. But that's what I would say.
Hi, I'm back here, purple hat.
Oh, okay, yeah, thank you. Sorry.
Yeah. I'm Susanna. I want to understand a little bit better the scope of your analysis by trying to figure out what sorts of implications there are, if any, for the kinds of motivations we have to obey the law or to comply with the law. So when you are analyzing legal activity in your sense, in terms of social planning, and you gave various analogies with, parents and planning and stuff. When I think about that analogy, it strikes me that, like, if I make a plan for my kid, I can't really. Part of what enables me to be in a position to do that is because she's going to, take the fact that I've made this plan with some weight. So if she doesn't want to do what I've planned, she knows that has to be negotiated. Whereas if I, purport to plan my aunt's stay in Los Angeles, like, even if she knew I was doing it, which she doesn't, but even if she did, it might have like no weight for her. So it seems like in order for there to be planning, there has to be a kind of continuity of intention on the part of both the planners and the people for whom they're planned. So while on the surface it sort of looks like the scope of analysis is the activity of, you said, the legislators and the executors and the judiciary, it looks like my question is whether is legal activity really, because of the analysis you end up giving, extend to also the activities of the people whose plans are constrained by the law? And if they do, then is that going to have some implication about how, like, well, I've got to be motivated to comply with the law because it's the law? And then I'm wondering whether that's even true, because maybe I'm only motivated because there's this threat of coercion.
Yeah, thank you. Yeah, so the view is that no, that this is a theory about what makes the law law. It is not a theory about the obligation to obey the law. Okay, and the plans can still dispose people to act, not because they're disposed to listen to to accept the authority, the moral authority of the planners, but it may be that there are other planning structures that will impose sanctions on them if they violate the plans. So then, like, what is this account doing if it doesn't help us understand the moral obligation to obey the law? What is any of this doing? And I know that wasn't your question, but if I could just say, like, by saying no, it doesn't have this implication, I want to say it does actually have this really important implication. So on the theory that if law is a practice, is an activity of social planning, then it turns out that the way to interpret plans, the way to interpret the law, is continuous with the way that we interpret plans. And so, therefore, after I developed this account of law as a planning organization and laws as plans, I then would say, how should we interpret the law? Well, we should interpret the law as we would interpret plans. And how do we interpret plans? Well, there are several very important features, like what are the goals of the plans? What are the trust relationships between the planners and the subjects of the plans? What is the degree of pluralism in the community that make up the conditions for needing these plans? So the account is less about what are the conditions for the moral obligation to obey the law, but rather what is the law and how should we interpret it? Though I think there should be relationship between this and the moral obligation to obey the law. It's just that I haven't been smart enough to figure it out.
So no implications about what people's motivations are?
Yeah, I really believe that legal systems have to be super ecumenical. That is, it should be compatible with a bunch of communitarian hipsters dancing the hora versus a bunch of Ayn Randers who could care less about society and who are just trying to make their way to the top. I really want the account to be as motivationally neutral as possible.
Thank you, Thomas Brower. This is sort of in the same ballpark as Teresa's question, but I was not entirely clear on the motivation for the moral aim condition. So I do. It seems plausible that this is typically there, and I also get that if you have built it in your account, that putative counterexamples could be glossed as simply falling radically short rather than not having the aim. But why have it be sort of part of the theory in the first place? Why is it essential to something being a legal system?
Yeah, I mean, I'm not happy that it's there. It's just I feel like I'm forced to have it there because I feel like I can't distinguish things that have the same kinds of structures from legal systems. And so that's why I made the various the various claims that I did about why the law seems criticizable in the way that baseball isn't, why hunter-gatherers are not criticizable in the way that modern societies would be without law, why the Yakuza, even though they have very bureaucratic structures of planning that are compulsory, why are they not the law? Why do we react differently to the mafia don than we do to corrupt officials? They all seem to me to suggest that it's not just the case that when the law does something immoral that we can criticize them from the moral point of view, but that there's something that they're doing that they're failing internally, if you will. It's like they're, as if, like with assertion, it's maybe morally better to lie to somebody, but it's still failing from the perspective of assertion. Even morally speaking, it's a good idea. So it's that same thing. I feel like I was just forced into it, and now the theory is highly positivistic in the sense that plans are positivistic entities. It's not a natural law theory. It says that law does not depend on morality, and my positivist friends get really mad at me because I stuck this moral thing in there. And so, I didn't want to do it. So I'm the victim.
Whoa. Hi, Scott.
Hey.
Okay. This is a little bit of a flat-footed question, and if only there was someone here who knew something about international law, maybe they could help this. In the general presumption of validity, it strikes me that most states, at least prior to, say, you tell me the date, for most states there wasn't a superior planning organization, Y, that did not require them to demonstrate the validity of their rules. So that can't be satisfied. And then
I'm sorry. I cut. You're absolutely right. I just kind of cut out. One of the caveats that I have is precisely that. It's just that it's trivially satisfied if there's no superior planning organization, that it's true that any superior planning organization accords a presumption of validity. So it just trivially satisfied in those conditions. I was really worried about cases of kind of embedded legal systems.
So then, slightly related, and then I'm just wondering where international law falls on this, because it strikes me that it's not obvious that it meets all of these criteria, at least not fully, and yet there's lots of people who want to say there's international law, which is why I guess you just wrote a book on this. So
yeah, so so after I wrote this book called Legality, I was interested in international law, and I swore to myself that I was not going to write the planning theory of international law. And so I wrote a book that's readable, It's called The Internationalists: How a Radical Plan to Outlaw War Remade the World, which talks about the evolution of international law, and particularly the norm having to do with whether states were allowed to use self-help to enforce their rights through war. And the claim is that war was the main mechanism for enforcing rights. That is, the rule that war wasn't this lawless activity, but in fact it was the main way in which states enforced international law. And that all changed in 1928 in the Kellogg-Briand Pact, when the world actually got together and outlawed war. And that fundamentally changed the way that states behaved to one another with respect to the enforcement of right. Now, I tried really not to, because I wrote it with my co-author, I tried not to put words in her mouth about what the nature of international law, but I think international law satisfies all these conditions. It's really interesting, though. I don't have time to walk through it right now, but what I think is really important is the international law is a planning organization, but in a really different way. The way that domestic law works is that it makes and applies plans. The way that international law works is it formulates plans for others to adopt. And it also regulates what plans people are allowed to enforce through force. I would like to do that, write up the planning theory of international law, except that the idea of that kind of imperialistic, my theory of everything disgusts me. But I should do it. I do think it does apply well, just with variations. Yeah.
Thanks. Hi. Oh,
Hi.
gosh. So I also wanted to ask about the general presumption of validity. So it seems like in order for this presumption to hold, there needs to be something like trust or maybe just reliance or something between the superior and the inferior entity.
Yeah.
And then if that's there, then it looks like they might be part of the same group. That's because on the first page you talk about the unity of law requires that there's one group engaging in this practice. And then if Florida and the US are part of one group that's engaging in this legal practice, then it looks like maybe supremacy is back on the table. If it's that group, including the states and the federal and maybe the UN as well, who knows, then supremacy is back on the table as the thing that group has.
Right, great. So the thing that you're pushing on right now is what are the conditions for group individuation, right? And we know, at least with respect to the first 13 colonies, they existed before the federal government, right? Both in the Articles of Confederation and also the Constitution of 1787. And so then the question becomes, why do we think that Florida legal officials are in a different group than federal officials? I could give you the long answer, but the short answer is just kind of intuitively, the federal judges are not committed to applying Florida law, except in cases where federal law requires them to do so, whereas it's the opposite with respect to Florida law. Now, that's the short answer. The longer answer has to do with, I think, what are the conditions for sharing a plan? And I think that the conditions for sharing a plan is what group did the plan creators have in mind? And it's perfectly clear that the Florida Constitution had, Florida officials and whoever would take the offices after that, as opposed to federal judges and the like, and vice versa with the federal courts.
Last question, I'm afraid.
Okay, hello, it's me. just in front of you.
Hi, sorry.
So my name is Anna. So I try to be really quick. So I did understand that the 7 properties seem to play an essential role to characterize legal systems. But I wonder whether it's really the case that all of them are necessary. So couldn't you give me an example where we have a legal system, but one of the 7 conditions is not really fulfilled? And maybe I put the question the other way around. So my motivation is that I have the idea that some legal systems are not really supported by a moral aim. And so maybe your duty is to give me an example. How can you stop a legal system to be a legal system? So you try to answer the question, what makes a legal system a legal system? And I want to know, how can I stop a legal system to be a legal system?
So, so Lon Fuller, in the the morality of law, in the, I believe it was the last chapter. Was it the last chapter? He talked about 10 ways of destroying the law. What was it? I forget exactly what the thing was. I'm sorry? Yeah, 8 pathologies. What could this crazy, did he call him Rex? This crazy ruler do to destroy a legal system? And what Fuller thought he was doing was enumerating conditions that were so immoral that they would undermine what he called the inner morality of law, and it wouldn't be law anymore. What I think he did was showed how these 8 things make it no longer the case that the law is a sophisticated planning institution. And so that's not a full answer to your thing. It's just that in the history of legal philosophy, somebody did that. And what I tried to show at the end of my book is to try to show that those conditions were not really moral conditions, but rather conditions which undermined the planning organization, or our view about it as being a planning organization. Ultimately, I set out a theory. It's subject to counterexamples. I believe my favorite thing was the last system that I could not distinguish was the Catholic Church. So I was like, why isn't the Catholic Church a legal system on my account? And then for some reason, I don't know why, and I just all of a sudden let me just go to the Vatican website. This is what made me start learning about canon law. And I started reading, it's like, this is a legal system. So that was really lucky. I'm totally open to you sending, what about, this, and it may, mess up the theory. But I have worried about counterexamples for long time, and since no theory is immune to counterexamples, I fully expect that to happen one dark day. But please let it not be today. Thank you.
So I hate to, thank you.